Hi, my name is Andrew Kinney. I'm an attorney. I am licensed in Minnesota, Wisconsin, Ohio, and New York at the present time. We're in 2014. I'm here today to talk about Social Security disability. This is one of a series of videos on Social Security. I'm working from the ground up to explain as much as possible and get it out there. Having done this 20 years, my experience has taught me that the system is confusing, unnecessarily so, and the system is intimidating for those that are least able to help themselves, those that are disabled and sick. Okay, so these videos are an attempt to open up understanding of how Social Security works. This is 201. I have a series of videos on basic Social Security concepts to kind of ground level understanding of how Social Security works. Just the fact that I can do multiple videos tells you something about how what seems on the surface to be a simple thing is so unable to work. It becomes very complicated. I understand why some of the complications are there. Social Security makes them, at times, much more complicated than it needs to be, but we won't get into that right now. But in the Social Security Disability 201, we have the application, reconsideration, hearing stage, appeals counsel stage. Today we're going to talk about refiling. I mentioned just in the previous video, and since I had the same shirt, it wasn't that long ago, with most law, if you, let's say you had a car accident and you sue someone and you lose, your right to keep it going is to appeal it. And the appeal is limited to errors that happened at the trial court. If you lose that, you can appeal and there may be nowhere to go. The concept, res judicata, thing already adjudicated, the concept, the legal concept is you can't just keep going and suing over the same issue. There is some resolution. Either you yes or no, and if there are errors, you fix it. But you can't just keep trying to go to court and saying, I want to sue, I want to try again. The idea is that if you are allowed to do that, then people would just keep filing lawsuits indefinitely. So that's a general concept that makes sense. But Social Security is the exception. If someone is disabled, it is not so easy to understand why. We have to define, well, what is limiting them to less than full-time work. Someone can, the way Social Security works, we all pay in with our payroll, with some exceptions if you opt out in some states for state disability, but on a whole, we pay in our payroll for the Social Security disability system. This is our system. When we pay into Social Security disability and then find we can't work, people expect that this system would work. Now, I'll give you an example that would maybe clarify a point I'm going to make. Let's say that you got in a car accident and you called your insurance company and it took them 2 years for an adjuster to come by to decide whether you were totaled your car. That, in essence, the analogy is a hearing. That's 2 years from when you apply. It would be incomprehensible for an insurance company to be able to function that way with long delays. So we have inserted in the application, we have an application process inserted, which makes sense. Let's find out if they're valid cases. We have a step inserted here, reconsideration, which I know it's commonly done. If you ever want to get a process where fewer people ask to exercise their rights, stick in another step. Why not reconsideration? How about reapplication? Well, today we're going to talk about the idea that if this system, for those that legitimately can't work, and the evidence was there, and there were errors, but the appeals counsel failed to acknowledge them, which is common, then we have a refiling. With Social Security, let's say you're limited to sit-down work and and you do painting, and you could be denied for medical problems. Let's say heart problems. You could be denied all the way through if you're 48 and 49, and let's say you're 49 or 48 and you go through this process, you can go to the appeals council and they say you can do sedentary work. Well, what Social Security has set up is when you pay into Social Security, and this goes into the date last insured concepts in the prior videos, when you pay into Social Security, you're covered for disability insurance beyond when you stop working. Generally, a rule of thumb is 3 up to 5 years. You have a date or last insured, a window of time to prove you're disabled. Well, if you apply, let's say you stop working and apply right away, and 2 years later, Social Security says you can work at a sit-down job, and then within that window of time you turn 50, that's an important change. This is an example where refiling makes sense. And the reason I say that is because medical problems get worse over time, all right? And age everyone ages over time. There are laws that acknowledge, they're called medical vocational guidelines, that when you're 50 and older, or near 50, within 6 months and older, once you hit those ages, Social Security needs to treat you differently. In the real world, it's much harder to get jobs. It's much harder to retrain, do new things. All the discrimination and difficulties people that are 50 and older have are all subsumed into the medical vocational guidelines, or as it's been played out. The original intent of the medical vocational guidelines was to systematize denials, but as it turns out, it helps, the medical vocational guidelines help acknowledge that people have a tough time doing new things at certain ages and actually getting jobs. Again, Social Security is looking at just the medical evidence. If someone can't read, the idea that you can't apply for jobs is not a medical question. The real question is, vocationally, at a job, if you can't read, how are you limited? But I'm going to move back to this point here. If you have a legitimate person that is limited to sit-down work through a whole process here, and let's say they really couldn't do sit-down work, but they were alleged they could, well, they are allowed to refile because, again, we have a window of time to prove from when you last worked, usually up through 5 years for maximum. That date last insured can be later. You're allowed to start a new case later, okay? The theory is that I guess you started too early. But in any event, if someone turns 50 and they get denied because of limited sedentary work, those same limitations can perhaps approve them on their 50th birthday. Refiling makes sense. I mentioned in my last video that when someone's denied at a hearing level, currently, unless the law is rescinded, the ruling is rescinded, 11(2)P, right now you have to choose, do I go to the Appeals Council now, it's your only chance, or do you waive it and start a refile right away? Appeals Council is asserting at least a year of wait to get to a refile. If you choose to do Appeals Council, with very rare exception, you're pretty much stuck to wait around to refile a new case, all right? And Appeals Council's results are poor enough that there's nothing to rely on, which says a lot about how it's set up, unfortunately. They're good people, always good people in this process, but the process is not well thought out, and I can be clear on that. Refiling allows someone to start a new case. If there is a hearing denial and someone went to Appeals Council and they lost, they decided to not review it, which is ironic. They review it to say they're not going to review it. These are all semantics. Then a refile would say that you're starting a new case. The back pay possible would be at least the day after the hearing forward. So the hearing is the hearing denial date, the decision date. We have to work after that date. So if you start a new case, I tell people, if you refile, we're not getting back pay any earlier than that last hearing denial, although there are exceptions to that. But ultimately, and that's where an attorney comes in, a refile is looking forward in time and is stuck with the hearing decision as a general rule, okay? So refiling isn't perfect, but if someone is at a different age, or let's say they had a cardiac problem at 30 and then they need a heart transplant and they are covered through disability insurance even later, within 5 years, they refile and they can be approved when they apply. There are instances, and we should have studies on this, of how many people refile and get approved and they find them disabled the day after the hearing. What that basically is saying is that by definition, if an application is approved and they're found disabled the day after the hearing denial, that the hearing itself is faulty, the hearing decision. It seems quite obvious, actually, that an application approval on a refile essentially says the hearing decision should automatically send for a new hearing and lock in that later decision. These are unfortunately logical concepts that don't always come up, but they are very apparent to me. Here, that was an overview of the whole system and the refiling. Not everyone can refile. If you're eligible for supplemental security income based on financial need, as long as that financial need's there, you can refile. Some people refile a lot. If you have disability insurance, you cannot refile if your date last insured is before the hearing decision date. So that's where you talk to an attorney and find out, well, what are my rights? And I will end this class. Thank you. If you have any questions about Social Security disability, just call the number at the bottom of our screen.